Good afternoon, everyone. I'm John Amodio. I'm chapter chair for SCORE Staten Island. I welcome you to this independent contractor or employee Do You Know the Difference webinar. It is being hosted by Richmond County Savings Bank. We thank them very much for the funding needed to help make this happen. They have been a great partner for us, and I look forward to have them helping us for some future ones as well. SCORE is a national organization. We wind up providing mentoring services to small businesses that are getting started, or those that have been in business and want to grow. We wind up helping them build, grow, thrive. We do this by providing services on our phone, email, text messages, and more these days virtually. We've been doing it in person, and we're going to be going back to in person pretty soon, but haven't been doing so because of the pandemic concerns. Today, we have with us well, let me give you first a couple of things that are happening. First of all, your line is going to be muted. So please use the Q&A versus the chat if you have any questions. Copies of all the slides will be sent to all the attendees. And we ask you at the end to please complete a brief survey that will be sent to you at the end of the webinar. Another thing that we will be doing is this program is being recorded. We will post this to SCORE's website as soon as we can. And to the attendees, we will send you a copy of the recording as well. Let me tell you a little bit about Karen Hall. Karen Hall has over 25 years of experience in human resources. She is 7 years as a human resource consultant with Paychex, and her areas of expertise include employee training, development, compliance, employee relations, and hiring. I have worked with Karen in the past, and she has always been very helpful, knowledgeable, and if there's anything that do not get answers to today from her presentation and have any questions, you can always contact her or myself after this meeting is over. What we're looking to do at this point is have her make a presentation, and we'll take care of questions and answers at the end. So again, if you have any questions, please enter them in the chat versus the Q&A. Karen, if you would, please, maybe you can get started with this webinar.
Absolutely. Welcome, everybody, to this beautiful afternoon outside. I sit in my office with windows all around me, and it's a gorgeous day outside. So thank you for getting away from that gorgeousness and joining us for about an hour here today to talk about independent contractors or employees, and how do you know the difference? This is a huge topic. I'm going to go over some really high-level information, maybe a little bit of background and a little bit of what the difference is. I will reference many times throughout this seminar that you should talk to your attorney if you have any doubts or questions or confusion about it. This is an area where the legislation is changing constantly. What used to be a legitimate 1099 10 years ago in certain businesses is not anymore. I worked with a client last year in transitioning, she's in construction, and transitioning all her employees, which she called 1099s, to W-2s, because they really are employees under the regulations now. So let's get started. I am going to turn off my video for the presentation, but I will come back on at the end. So independent contractor employee, how do you know? Before we get started, quick legal disclaimer. This Paychex seminar is for general information purposes only. It should not be considered legal advice or interpreted as a legal opinion of any specific facts or circumstances. We encourage you to consult with legal counsel concerning your own situations or for any specific legal questions you may have. So independent contractors' employees are not the same, and it's important that you, as a business owner or manager, understand the differences. It's equally important to understand that worker classification laws exist at the federal, state, and local level. In the early 1900s, Congress adopted the employee independent contractor distinction to define the coverage of New Deal era statutes that were designed to protect workers. Employee versus independent contractor status determinations have frequently been the subject of litigation, as well as regulations and legislation ever since. Where legal rights and protections are concerned, the differences between employees and independent contractors in American tax, labor, and employment law is monumental. Employees are protected by numerous statutes, such as state workers' compensation laws, the National Labor Relations Act, unemployment insurance laws, anti-discrimination laws, and wage and hour laws. Individuals may not be covered under employment laws where they do not meet the definition of employee under an applicable law. Determining whether a worker is an employee or an independent contractor is not an easy thing to do and should not be taken lightly. It is further complicated by the fact that worker classification may be defined differently under different laws and enforced differently by different government agencies. A worker's classification potentially affects payroll, wages, taxes, and who's responsible for paying those taxes, eligibility for workers' compensation and unemployment insurance benefits, eligibility for company benefits, and protection under federal, state, and local laws. So classifying your workers, our objectives. So during the seminar, we're going to review the applicable definitions of employee and independent contractor. We're going to go over employer or business owner responsibilities, go through some steps on how to determine worker classification, review some misclassification concerns and consequences, and touch on some common mistakes that I see employers make all the time. So to start with, what is an employee? Whoops, sorry. These are timed, so I might be off a little bit. So the determination of a worker's classification cannot be made based upon any one factor, as different agencies use different criteria. For example, the Internal Revenue Service, the IRS, generally considers anyone who performs services for a business to be an employee if the business can control what will be done and how it will be done. This is still generally the case when an employer allows a worker the freedom to make certain decisions and act upon them. The IRS maintains that the employer still retains the right to control the details of how the service will be performed. So I just wanted to go over a quick scenario for you to kind of illustrate this. Debbie Smith is a salesperson employed on a full-time basis by Bill Blue, an auto detailer. She works 6 days a week and is on duty in Bill's showroom on certain assigned days and times. She appraises trade-ins, but her appraisals are subject to the sales manager's approval. Lists of prospective customers belong to the dealer. She has to develop leads and report results to the sales manager. Because of her experience, she requires only minimal assistance in closing and financing sales and other phases of her work. She is paid a commission and is eligible for prizes and bonuses offered by Bill. Bill also pays the cost of health insurance and group term life insurance for Debbie. Is Debbie an employee? Debbie's likely an employee for several reasons. A general rule is that anyone who performs services for you is your employee if you can control what will be done and how it will be done. As we discuss the details of making this determination later on, think back to this scenario and which factors support the classification of Debbie as an employee. In an employer-employee relationship, the employer is responsible for withholding income tax and a portion of Social Security and Medicare taxes for employees. As the employer, you must also pay Social Security, Medicare, and unemployment taxes on the wages you pay to your employees. Most employers also have to pay Social Security and unemployment tax. Employers are required to issue Forms W-2 annually to employees and report employee wages quarterly on the Form 941. Form W-2 is a statement that must be prepared each year that details an employee's total gross earnings, Social Security earnings, Medicare earnings, and federal, state, and local taxes for the employee. This form must be provided to the employees no later than the end of January with information from the previous calendar year. Depending on company policy, employers may be required to provide certain fringe benefits, such as health insurance and paid vacations to employees. Employers must also comply with all applicable federal, state, and local statutes designated to protect covered employees, such as wage and hour laws, leave laws, etc. Best practices when utilizing independent contractors. So think of these best practices. Complete an assessment to determine worker classification. Such an assessment should look at all of the applicable laws and regulations that the employer is covered by. Many employers consult with legal counsel if they're not sure if an individual can be classified as an independent contractor. A written agreement. You may wish to have a written agreement detailing the terms of your relationship with each independent contractor. An independent contractor agreement or contract isn't required and it's not definitive for purposes of classification, but it might include the following information: a description of the services provided, payment for the services, the relationship of the parties, work product ownership, intellectual property, confidentiality and security of information, and terms surrounding the termination of the relationship. A best practice is to consider an agreement that includes clear expectations detailing the job to be done rather than the manner in which it's to be performed, as well as a specific timeline for the completion of services. Once again, consulting with legal counsel is recommended when drafting an independent contractor agreement. Documentation and record keeping. This is also important when managing an independent contractor relationship. Keep records regarding the independent contractors that you may use for your business and have these records readily available in the event of an audit. To help with this, consider keeping the written agreement for services, all invoices for services, business cards, and proof of insurance in a common folder. Comply with all applicable requirements when obtaining services from an independent contractor, which includes completing the Form 1099 each year where applicable. Business owners are required to complete a Form 1099 for vendors, subcontractors, independent contractors, and others working as independent contractors when the individual receives $600 or more from you in the calendar year. State and/or local record keeping requirements may also apply. Making the determination. No one factor is regarded as controlling and making the employee versus independent contractor determinations. So you should consider, let's start with the IRS guidelines. According to IRS guidelines, an individual is likely an independent contractor if the payer has the right to control or direct only the result of the work and not what will be done and how it will be done. The earnings of a person who is working as an independent contractor are subject to self-employment tax. Refer to the IRS website for more details on that self-employment tax. The Internal Revenue Service and the courts generally look at a variety of facts in determining worker status. The IRS Common Law Employee Control Standard groups facts within three primary categories: behavioral control, financial control, and relationship of the parties. The important point to remember is that you must consider all the facts when making a determination, as no one fact provides the answer. In determining whether the person providing the service is an employee or an independent contractor, all information that provides evidence of the degree of control and independence must be considered, including the extent to which the worker's services are an integral part of the business, the permanency of the relationship, the amount of the worker's investment in facilities and equipment, the nature and degree of control by the principal, the worker's opportunity for profit and loss, the level of skill required for performing the job. So let's dive a little deeper into these three categories. So the first, behavioral control. Does the company control or have the right to control what the worker does and how the worker does his job. Financial. Are the business aspect of the worker's job controlled by the employer? These include things like how the worker's paid, whether the expenses are reimbursed, who's providing the tools and supplies. The type of relationship. Is there a written contract or employee type benefit in place? For example, a pension plan, insurance, vacation pay. Will the relationship continue? And is the work performed a key aspect of the business? Businesses must weigh all these factors when determining whether a worker is an employee or an independent contractor. Some factors may indicate that the worker is an employee, while other factors point to the fact that the worker is an independent contractor. There is no magic or set number of factors that makes the worker an employee or an independent contractor, and no one factor stands alone in making this determination. Also, factors which might be relevant in one situation may not be relevant in another. State laws. It's important just to keep in the back of your mind that state laws may differ from federal laws. Most of the time, the state regulations are more stringent than the federal laws. So what's the big deal, right? So you classify somebody as a 1099, IRS DOL comes in and they say, we disagree with you and we're, going to punish you for this now. What could happen? Well, there are civil and criminal penalties. Misclassification can result in fines as well as civil and criminal penalties for your company, including, but not limited to, back federal taxes, up to 1.5% of wages paid for failing to withhold employee income tax, 20% of an employee's share of FICA, 100% of your share of employer taxes, 100% of FUTA taxes, liability for unpaid overtime and back pay, and benefits and or benefit contributions, including but not limited to potential 401k contributions. If you're found to have failed to provide an independent contractor with a Form 1099, you may also face double federal penalties. If you are found to be intentionally misclassifying employees, your company may be subject to greater fines and penalties. In addition to facing fines and penalties at the federal level, your company may also face fines and penalties at the state level. Some states may more aggressively enforce misclassification than others. For more guidance on your state guidelines, refer to the www.irs.gov website, state websites, or your own legal counsel. So, some common employer business owner mistakes. So here's a list of some of the common mistakes employers and business owners make that could result in misclassification of workers. This is not an exhaustive list. So only considering one or just a couple of factors. Employers should not base worker classification on one or two factors, but review all aspects. For example, basing the relationship on a signed contract or the fact that a worker does assignments projects for more than one company may not be sufficient. Not following standard guidelines. Don't just do something because another business has done it. Refer to the IRS guidelines, the US DOL fact sheet number 13, the administrator's interpretation number 2015-1, as well as applicable state guidelines, and even consider consulting with legal counsel when attempting to classify your workers. Taking advice from friends. Remember to only take advice from a reputable source when trying to determine worker status. This might include your CPA or legal counsel. For example, if you start someone as an independent contractor during onboarding to save on unemployment taxes because a friend did it is not a defense. Going it alone. Failing to consult with legal counsel when you are unsure of a classification and when creating a binding independent contractor agreement may be an issue. Not double checking documentation. Always confirm that an independent contractor has his own workers' compensation insurance. And as I stated previously, you would want to have the documentation from them that they do have it. Letting the worker make the determination. Classifying a worker as an independent contractor because the individual asked you to is also not a defense. Even if a worker signs a written agreement that they agree to it, the business is still responsible for the proper classification of workers and would be responsible for any potential fines. Treating independent contractors as employees. So this would be providing an offer letter or issuing an employee handbook to the individual, giving them a benefits package that might look a lot like what an employee would receive, which could include health insurance, paid time off, paid holidays, leaves, retaining an independent contractor for a lengthy period of time, generally looked at as more than a year, or having an individual perform the same or similar services as an employee, but classifying him as an independent contractor because you don't think you'll need him permanently. Just as a side note, if you have two people doing the same thing and one is classified as a W-2 and the other one is a 1099, that is an issue. And you cannot hire somebody temporarily as a 1099 to try them out and then transfer them to a W-2. A position is either a W-2 or a 1099. Using the wrong language. When using independent contractors, you should never refer to them as 1099 employees. Form 1099 is a government tax form issued to independent contractors, not employees. Also, avoid the terms hiring and firing when referring to independent contractors. Independent contractors are neither hired nor fired. Their contracts are simply fulfilled or terminated. Avoiding some of these common pitfalls can help you avoid liability when classifying your workers. The conservative approach, when in doubt about a worker's classification, may be to classify the individual as an employee and comply with all applicable laws in an effort to avoid the potential back taxes, fines, and penalties associated with independent contractor misclassification. IRS safe harbors. As an employer or business owner, you may have a defense or safe harbor against these fines and penalties if there is a reasonable basis for the determination you made. Examples of a reasonable basis may include judicial precedents, published rulings with respect to the taxpayer, or a letter of ruling to the taxpayer, past IRS audits. Note this is only applicable if there is no penalty assessment related to the treatment of individuals holding substantially similar positions in the business. Prior audits must have included an examination for employment tax purposes of whether the worker or anyone in that similar position should be treated as employee. Or a long-standing recognized practice in a significant portion of the industry. This is changing. And like I said in the very beginning, just because people were classified as 1099s in your business 10, 15 years ago, doesn't mean that those same standards apply. Employers or business owners may be denied safe harbor protections if they inconsistently classify workers who are doing the same tasks, or if the employer has not filed the appropriate tax forms consistent with the treatment of the worker as an independent contractor. Employers are therefore encouraged to treat all individuals considered to be independent contractors consistently and to file required tax forms. Consult your own legal counsel for more guidance. So you'll get, when you get a copy of this seminar, you'll get a whole listing of a bunch of different sites that you can go to. So just to reiterate, you can go to legal counsel, you can go to your accountant or tax professional. If you're with Paychex and you're on our HR services platform, you can talk to your HR generalist about your classification. But here are these resources. So when you get a copy of these slides, you'll have these. You don't have to copy these all down right now. But I use these when I work with one of my clients on, whether or not somebody is a 1099 or a W-2. I use these resources to help guide them through. So this will be a great tool for you to have. So I know I really just touched on everything at a super high level. And anytime I do this seminar, people have lots of questions for me, and they're usually very, very specific to their business and what is this person, should this person be classified as this, or can I do this? And I'm gonna say I can't answer any of those questions in this format. As I said, when I work with my clients, I go to all those websites. There's certain forms that we fill out. There's duty tests There's all sorts of things that we can do. So all I can really give you today would be some global questions for you. So with that being said, I think we have a couple of them that have come in. Is that correct, John?
Yes. Yes, there are.
Okay. Now, do they go into the chat or do they go in through the?
Yeah, like you went to the chat. There's some here. Have some people that are doing business, and one says here, I am doing online business now, and I am planning to hire some freelance teachers or translators to work for me.
So I guess the question is, are
They will live in the US. They would be independent contractors to work for me. So what kind of documentation should I ask them to provide? I would prepare a 1099.
So
Also, can I work with another company and treat it as if it is an independent contractor?
So on a high level, a couple of questions. I guess this comes from, what would be the nature of the business? So if your online business is teachers and translators, I would be very careful about labeling them as 1099s versus employees. What would you need if you are comfortable? You've spoken to your legal counsel and they agree that they could be classified as 1099s. What sort of documents would you need? Well, you would have to prepare the 1099 if you end up paying them more than $600 within any calendar year. But as I said in the webinar, having some sort of contract in place with exactly what is going to be their role, how long is that role going to last, what is the compensation going to be? Those are all individual things. Once again, we recommend that you get with legal counsel to have those developed because it does become a contract and you don't want to put something incorrect in there and then end up being sued over it. So you want to talk to an attorney to start with. And a big one is also, if this is their business, do they have a business card to show that this is what they do? And they should have workman's compensation insurance in place to cover themselves, because as a 1099, they are not covered under your plan. Also, can I work with another company and treat it as an independent contractor? I guess I don't quite understand the question there. So let me keep going. Can I hire a non-immigrant alien to work for me as an independent contractor? This person is qualified for my needs? This crosses over into a bunch of things. Now, first of all, you're not hiring them, right? Because they're a 1099. So we don't hire and fire 1099s. As far as a non-immigrant alien and their 1099 status, they would have to speak with their CPA or tax professional as far as what documents they would need in order to file taxes. There are special tax requirements. I am not a CPA, but I do know that they would have to get a TIN, I believe it is, that they would be able to file. Were there any other questions?
Okay, are there any other questions that people might have? Karen, it looks like you're getting it off easy today.
I know, this is unbelievable. I can fill in a little bit and just add a couple of things to it. The big one that I see, and I mentioned this, is calling them 1099 employees. Once again, they're not employees. So they're an independent contractor. Make sure you don't use that employee language in there. They shouldn't be invited to meetings. I've had that one come up quite frequently, that I actually was presenting the New York State sexual harassment prevention training to one of my clients who I knew had 1099s. And in the introduction process in the beginning, lo and behold, a bunch of their 1099s were at my training. Not a good idea. It blurs that line between 1099 and W-2. And the last piece of the puzzle, and we were talking about this before we started, Making sure, that's where that written contract comes in, making sure that a 1099 knows that they are a 1099 and kind of what those requirements are. Where a lot of clients get into trouble is that they haven't done their background, their work, they haven't documented it. They have a 1099, they say the contract's done and, you know, sever that relationship. And that 1099 goes and files for unemployment, which they're not covered by. But what that does now is it tells the DOL that there may be some issues with that classification, that that 1099 was not aware of what the relationship was, and potentially that they were an employee and were treated like an employee, hence them filing for unemployment. So be very, very careful of that.
Karen, the was further clarification of the question about another company. The person says, can I work with another company to let them do some work for me? And they pay all the, they pay it all as if, pay it as how I would pay an independent contractor.
So yes, to a certain extent, if you think, I work for a payroll company, right? So there's a lot of businesses that use Paychex to process their payroll. So Paychex charges them a set fee for performing that service. So if that's what you're talking about, then yes, you would be paying another company for a service that they are providing you. Just like if you paid a plumber to come and fix your toilet, you would pay that plumber to take care of that specific job for you. Where you may run into trouble is if you're paying this company to do the same thing that your employees are doing.
You know, they have these companies that provide part-time help. You know, my accountant or my bookkeeper is sick. Can I hire some bookkeeping, get some bookkeeping services? I would think that they would be considered under contract with the agency that provides the bookkeeper, and that
Yes.
agency winds up paying the bookkeeper.
Yes, so
as
they
an
are
employee.
generally employees of that other service, and you're
Mhm.
hiring them as a temporary employee. So you're going to pay that staffing service a fee, and then the staffing service pays their employee appropriately, and the employee would be covered under, you know, all those laws that protect employees through the staffing agency. You're not paying that person working directly for you. You're paying for a service from that staffing agency. So it's a complex relationship that's there.
So that relationship wouldn't even be an employee or an independent contractor. It would be a fee for services.
Yes, so they are a temporary employee. So that can be severed at any point in time very easily by the person paying for that. But the staffing service has to still treat them like an employee. So they are still responsible for all the other pieces of the puzzle that are out there.
Mm-hmm.
It's ooey gooey. I don't recommend anybody to do that. I'm gonna be honest with you, this day and age. You're paying usually 2 to 3 times as much what you would pay, but just by hiring somebody yourself. There may be certain circumstances, maybe you are a tax company, you need extra reliable bookkeeping help just for a very short period of time. But in general, if you're using temps all the time to fill in holes, you'd be a lot better served to go and hire somebody for yourself.
One of the things that's happening, Karen, is we're finding, but because of the pandemic, people have not been working for a long period of time, and now they're starting to come back to work. And employers are trying to decide, you know, how do I bring this person back? Do I bring them back as an employee? Do I just use them periodically as I need them? The question would come sort of, is this person a part-time employee versus an independent contractor? type of thing. I would think that that's what they would be facing, that type of a question.
Yeah, I think it kind of depends on the role. So this was a previous employee that left and is now coming back. You know, you could hire them as full-time, part-time, per diem, seasonal, as long as the employee, you know, is aware of that and agrees to that, then there's no issue with any of those. In general, per diem, part-time, seasonal work, it's a very, very narrow field of who's going to be interested in that. And surprise, surprise, employment's a law, all apply equally, whether the employee is full-time, part-time, per diem, seasonal, and works for you one day or 1 year. So it doesn't lessen your responsibilities to that employee by not hiring them in a certain way. And with the market the way it is, that if you think this person is going to be full-time, why would you hire them part-time? You know, they might be looking for a full-time job and they're going to go find another one because you didn't do it from the beginning. So something to think about.
Okay. Are there any other questions that anyone has at this point?
I see in the Q&A, somebody put what suggestions I have about hiring independent contractors on sites. I am not aware of that site at all, so I can't really speak to it. Each industry kind of has its own niche of where you can find people. I would just make sure that you have your documentation. You know, there are some fields where, you know, 1099s are still the standard. They should have the paperwork for you. They should be able to tell you the other places that they're working. They should be familiar with a contract. You know, it shouldn't be a surprise. It's not something that somebody does just on the side. And it is something that I fully would expect that 1099s will probably be nearly non-existent in the next 15 to 20 years. I think the move is for everybody to be a W-2. I didn't really answer your question about that, but I'm not familiar with it, so I apologize. All right.
Okay. Can you move us to the last slide for a moment, Karen?
Yep.
Okay. Again, I want to thank everybody for attending. There's a little bit of a bit here telling us about what SCORE is. And there's ways that you can get in touch with us at SCORE. You can do it, of course, by visiting our website, telephoning us, and going on Facebook or LinkedIn. This, as I said earlier on, maybe I didn't say it clearly enough. Now, this webinar is being recorded, and we will post this to our website in our library. We will send you a copy so that you could look at it, but anytime you want to refer to this webinar and several others that we have that have been recorded, you can go to our website, which is statenisland.score.org, and you will find webinars, you will find the videos, you will find a number of articles, other blogs, other pieces of information that could be very helpful to you. And there will be also ways that you could contact a mentor to meet with you and talk with you about your specific questions that you might have.